Supreme Court hears oral arguments in Olivier versus City of Brandon. This is a case about whether a person who pleaded no contest to violating a city ordinance can later file a lawsuit to challenge that same ordinance as unconstitutional. That's interesting. So there was some noise ordinance or something saying you can't take your bullhorn out here on the street corner at this time or whatever. And he says, fine, I violated it. I plead essentially guilty. Okay, no contest. People think that means like you're innocent. No, it just means you're not really contesting it without admitting your guilt. So then after he does that, can he then go and challenge the law? Here's what it sounds like from the Supreme Court today.
Because it's a facial challenge. We'll find out.
Sotomayor.
But the question you're saying is he is going to be barred.
Unless and until he is able to achieve a favorable termination.
How do you deal with Edwards? How do you deal with Edwards remanding for the prospective relief to change the disciplinary procedure?
So certainly the language in Edwards is ordinarily a prospective claim would be barred, would not be within the ambit of Heck. We're very comfortable with the ordinarily language because ordinarily does not mean always. And if there is ever a situation there where
the procedures that he was attacking were the same ones that he raised in his past disciplinary proceedings. So I don't know why just wouldn't have just ruled.
As I understand, it was the date stamping procedures, and it was unclear in the case whether or not those date stamping procedures had actually been applied. And even if they had, Justice Scalia would say you apply the test, and it's either a thumbs up or thumbs down determination. And if it's outcome neutral and it wouldn't result in a disavowalment or a collateral attack, then that's okay. But in this particular circumstance, there can be no greater impugnment on the prior conviction than a declaration that the law was unconstitutional.
Didn't we say the opposite of what you're saying? And Woolley is this case. And we came to the opposite result from what you're advocating.
Woolley is pre-Heck abstention case by its own language.
It is pre-Heck. If Heck did not exist, the way we would do this is we would say we have this case, Woolley, and Woolley just decides this case. And
yeah, what the heck indeed. All right, lots of case law that they're kicking around, and it could be an interesting one to see how they decide. It sounds like we've got some pretty clear lineage of the case, and they accepted a petition, so maybe they'll be reversing something or might have something substantive coming out of there, but we'll see. So that's what's happening in SCOTUS today.